This is Red Cedar Flats LLC versus America by Rail Inc., docket number 20-329CB. This is the time set for hearing on the plaintiff's motion for summary disposition under MCR 2.116 C8 and C9. And before we start, I'll take your appearances just for the record, please.
Good afternoon, Thomas Eckhart, appearing on behalf of plaintiff.
Good afternoon, Emily Burdick, on behalf of defendant.
All right, thank you. Mr. Eckhart, go ahead.
Yes, thank you. This is plaintiff's motion for summary disposition. The case involves a commercial lease between the plaintiff, the landlord, and the defendant, the tenant. And so we filed our motion under C8 for the counterclaim and C9 with regard to the breach of contract complaint. The term of the lease lasted through the end of this year, and defendant bases its counterclaim and defenses on a force majeure clause, arguing that COVID and the stay-at-home order from the governor constituted a casualty under the lease. Force majeure clauses are to be interpreted narrowly.
Mr. Eckhart is frozen. We'll see if this resolves itself in a minute.
Casualty.
Okay, Mr. Eckhart, you
Yes.
froze up. You froze up. So you were saying force majeure clauses are interpreted narrowly, and that's when you froze.
Okay. Okay, am I back?
You are.
Okay. Here the language is not ambiguous. If you look at the paragraph concerning force majeure, it refers to a physical event. And in this case, there was no physical event. It refers to a fire or other casualty, insurance proceeds, damages to the premises, and restoration of the premises. So if you look at the context of the paragraph itself, it's clear that this does not refer to a virus or some governmental action. So there was no force majeure event, and a downturn in business is not generally a force majeure event. Further, the defendant argues that it's not liable due to impossibility, but the affirmative defense is very vaguely pled and doesn't have the requisite facts as you would expect with regard to MCR 2.11 F3. There's nothing in the pleadings that indicates that it was permanently impossible for the defendant to operate its business. And this is especially true where the executive order cited expired in June. This case is distinguished from the Bissell case that's cited by defendant, where in that case, the defendant, when they were contracting, was aware of a potential problem and failed to notify the plaintiff of that problem. For these reasons, we'd seek summary disposition on both the complaint and the counterclaim.
All right, thank you. Ms. Burdick?
Thank you, Your Honor. So this is not a typical landlord-tenant dispute case. It's actually atypical. The parties have had a 24-year landlord-tenant relationship. America by Rail has defaulted on rent prior to the allegations in the complaint in the 24-year history. Furthermore, what makes it more atypical than a typical landlord-tenant dispute is the fact that a once-in-a-100-year pandemic is the cause of the issues between the parties. It's a pandemic that no one could predict, no one can control, and one that is constantly compared to the Spanish flu of the early 1900s. ADR disposition is not appropriate at this time because of the parties' contract clause 9A that Mr. Eckhart read. Specifically, it states if the premise shall be rendered untenable by fire and other casualties, then in summary, the rent can be abated during that time. The operative clause here is other casualties. Plaintiff would like the court to read other casualties as not including a pandemic, because it was not specifically listed. But just because something is not specifically listed in the contract clause does not mean it's not contemplated by the parties to the contract. Otherwise, that same vein of argument, bloods which are not listed would not be covered, tomatoes which are not listed would not be covered. So other casualties have to read to exclude what that is, other casualties. Defendant cites in its brief the Buffer case, where any other benefits was the operative clause within provision that was being interpreted by the court. And the Michigan Court of Appeals interpreted that to include pension plan liabilities, even though it was not specifically listed in the provision itself. Additionally, it's well established that a canon of contract interpretation is to construe the contract against the drafter. The pleadings in this case do not show who drafted the contract, but further discovery on this issue will indicate that plaintiff was the drafter of the contract, and therefore weight at some point in the future has to be given to ABR's argument in contract interpretation. It cannot be disputed that the pandemic is a casualty. Hundreds of thousands of people have died from it. 7 months later, we're living in it, and that's the reason why we sit before you today on Zoom instead of in your courtroom, Your Honor. The rules of evidence, 201 and 202, as well as Michigan Supreme Court case law, allow you to take judicial notice of the executive orders. The Supreme Court case I am referring to is Hack v. Maple Valley School, which is in Michigan 516. So summary disposition, is not appropriate at this time because ABR has asserted additional defenses that plaintiffs did not to have summary disposition on, and as Mr. Eckhart refers to the doctrine of impossibility. It cannot be disputed that the governor's orders in the state of Michigan made it impossible for people to travel, which hurt ABR's business, who is in the travel service industry, and also rendered different people, as ABR could not access it as it was ordered to remain at home. ABR should be able to factually develop this defense. Therefore, as I indicated, summary disposition is not appropriate. Finally, summary disposition is not appropriate under C8 because the parties have not had a chance to develop facts of whether or not plaintiff self-materially performed all contract obligations. The governor's orders required many businesses in order to return back to business, and it has not been established whether or not plaintiff has followed all the orders and followed all the obligations in order to provide a tenable premise. All in all, the pandemic and the landlord disputes are novel issues being brought before the court, given such extreme circumstances that the world, the United States, Michigan, and the parties are living through right now. And therefore, we ask that summary disposition motion be denied.
All right, thank you. Mr. Eckhart, you want rebuttal time?
Yes, just briefly, Your Honor. Counsel argues at great extent about what's going on in the world and what are the effects of the pandemic and what may or may not have happened in the prior dealings between the parties. But in this case, we're limited to the four corners of the pleadings. And I think if we look at the pleadings and the lease itself, it's clear that it is unambiguous that this is not a casualty, and therefore summary disposition is appropriate.
All right, thank you. Well, I'm going to start first with just the counterclaim because it can be separated out easily. It requests declaratory relief and is based solely on paragraph 9.1A of the lease. And I wouldn't necessarily call that a force majeure provision. I mean, it is what it is and it says what it says, but it's 3 sentences long, and those sentences, taking out the non-essential words, are, if the premises shall be rendered untenable by fire or other casualty, landlord shall, to the extent of available insurance proceeds, restore the premises and make them tenable as soon as possible. Except in the case of damage caused by tenant, rent shall abate during the period of untenability. All such restoration shall be completed within 120 days of the premises being rendered untenable, or tenant shall be entitled to terminate this lease. So the defendant says that this provision, and I guess particularly the second sentence, allows for a rent abatement for at least May and June, when we were under a state of emergency and the governor had issued the so-called executive stay-at-home orders. And the defendant further says that although the paragraph as a whole refers to a casualty, there are various different dictionary definitions that support that a casualty could be more than just physical harm to the premises, and that the broad language, other casualty, creates ambiguity in this paragraph. I have to disagree with those arguments for multiple reasons. First, just because there's multiple dictionary definitions of casualty does not necessarily mean that there is ambiguity in this provision. Second, the entire provision has to be read as a whole. You can't just isolate the words other casualty and then rely on dictionary definitions from there. Also, the use of the words fire or other casualty calls for the reasonable interpretation that other casualty is limited to the same type of event as fire, and that would be something that physically damages the premises. Additionally, the rest of the provision addresses the landlord performing restoration, which also limits the provision to physical damage or the types of casualties capable of restoration. It also references insurance proceeds, and that as well would indicate that this provision is referring to the types of casualties that are capable of restoration, that are physical injuries to the premises, for which insurance proceeds could be used to correct the situation. So all in all, a contract is ambiguous when it's capable of 2 differing reasonable interpretations, and there simply is no reasonable interpretation of paragraph 9(1)(a) that would allow rent abatement for an event that doesn't cause actual injury, loss, or destruction to the premises. So stated another way, the provision, paragraph 9(1)(a), is unambiguous, and as an unambiguous contract provision, the court is required to apply it as written. So the counterclaim cannot be sustained as a matter of law, and the plaintiff is entitled to summary disposition as to the counterclaim. There is also the matter, and I would say as well that paragraph 9(1)(a) is also asserted as a defense in the answer affirmative defenses and counterclaims. So to the extent that it's elsewhere besides the counterclaim, it fails for the same reasons. But that also takes us to another defense that's set forth in the defendant's answer and in the affirmative defenses, and that is the affirmative defense of impossibility. Most of the other affirmative defenses do seem to be boilerplate. They haven't really been addressed, not only in the plaintiff's motion, they've not been individually addressed, but they also haven't been addressed in the defendant's response. I would say the exception is the affirmative defense of impossibility, so that's all I'm going to address. The plaintiff says first that impossibility as an affirmative defense hasn't been properly pled under the court rules. And of course, the court rule that applies is MCR 2.111 F3. I disagree with that. MCR 2.111 is a notice provision. It's designed to prevent a surprise defense. So if you're going to plead something as an affirmative defense, it has to have some facts stated, but because it's a notice provision, it doesn't require anything more than something that would prevent sufficient facts to prevent it to be a surprise defense. Paragraph 14 in the affirmative defenses says it has become impossible to perform the contract through an unforeseeable event or act of nature. And I would call that sufficient as a notice provision so that the defense of impossibility and the facts upon which it's based, which are just simply an event or act, an unforeseeable event or act of nature, is sufficient to put someone on notice that that is the nature of the impossibility affirmative defense. The plaintiff also says, though, that the defendants failed to plead a sufficient defense of impossibility because there's no explanation set forth in the pleadings and no explanation why the defendant didn't operate its business remotely and other reasons, such as there's no reason why the defendant couldn't operate through the end of the lease term. But I disagree with all of that because this is not a C10 type of situation where there has to be factual proof. This is a C8, C9 motion, and all that the defendant has to do is put forth a legally cognizable defense. Whether it can be proven or not, or to what extent it can be proven, is not a proper consideration for this motion. So I conclude that there is a legally cognizable defense of impossibility that the defendant has put forth. And for those reasons, I am denying that portion of the plaintiff's motion for summary disposition. So I'm granting it as to the counterclaim and anywhere else where the paragraph 9(1)(a) is asserted as a defense, and denying it with respect to the impossibility affirmative defense. And if one of you wants to do an order, you could just say, granted in part with a little more specificity than that, and denied in part, and for the reasons stated on the record. Granted in part as to the counterclaim is what I'm saying, so.
Thank you, Your Honor. I can prepare a proposed order.
Great. Thank you very much. That'll conclude our hearing.
Thank you.